Good day, lovers of wisdom of the law. Welcome to our lecture on criminal procedure.
Welcome aboard! We are your hosts, Carmel.
And DENMAR DEDUQUE. Together with our team, today, let's learn about jurisdiction in the criminal justice system of the Philippines.
But before we start with the discussion, please hit like, subscribe, and tap the notification bell so you'll be notified of our upcoming videos.
For this session, we will have the following objectives. First, elucidate how the criminal justice system works. Number 2, define the three kinds of jurisdiction. And lastly, discuss the jurisdiction of the lower courts. These topics will equip you with a basic knowledge of criminal procedure in the Philippines. Ms. Carmel, do you know the history of due process and how did it get started?
Yes, I think I have an idea. It may have started in the Garden of Eve. Based on biblical history, God left Adam and Eve in the garden with a simple instruction not to eat the forbidden fruit from the tree of knowledge. A snake came out and lured Eve to eat the forbidden fruit. Eve, true to her frailties, ate the fruit, and voila! They became violators of the law. God asked, "Did you eat the fruit?" Eve replied, "Yes, I did." He also asked Adam, to which he denied. Then God sentenced Eve so that she would bear the pain of labor, and that the man shall labor for his wife. There and then, the due process started. Is that right, Sir Denmark?
We have no way of knowing, Miss Carmel. Now, let's start the session.
Jurisdiction is the power of a court to decide a controversy. There are four basic requisites before a court can acquire jurisdiction over criminal cases. These are jurisdiction over the subject matter, jurisdiction over the territory, and jurisdiction over the person of the accused. Let's discuss the first one. Jurisdiction over the subject matter includes the power to determine whether or not it has the authority to hear and determine the controversy presented, and the right to decide whether or not the statement of facts that confer jurisdiction exists, as well as other matters that arise in the case legitimately before the court. Subject matter is conferred by law. Thus, it cannot be subject to waiver, acquiescence, agreement, or consent of the parties. Conferment of jurisdiction cannot be presumed. Thus, in order to ascertain whether a court has jurisdiction or not, the provision of law shall be inquired. In criminal cases, primarily in determining whether the court has jurisdiction over the subject matter is BP 129 as amended by RA 7691, Judiciary Reorganization Act of 1980. Over the subject matter is determined by the allegation and the information, not by the evidence presented during trial. It is determined by the penalty imposable, not the penalty imposed. Jurisdiction over the subject matter is determined by the law at the commencement of the criminal action, not the law in effect at the time of the commission of the offense, except those cases falling under the jurisdiction of the Sandigang Bayan, because it is determined at the time of the commission of the offense.
The second requisite is the jurisdiction over the person of the accused. This jurisdiction is acquired through arrest of the accused by virtue of warrant or voluntary submission to court's jurisdiction. Acts that are considered to be voluntary appearance include asking affirmative relief from the court, except when the special appearance in court is to question the jurisdiction of the court over the person. It is also considered to be voluntary appearance when an accused files a motion to quash or any other motion from the court, except when the ground is lack of jurisdiction over the person of the accused. Third, appearance of counsel during arraignment. Entry of counsel in posting bail without qualification also means that the accused is submitting himself to the jurisdiction of the court. To fully understand jurisdiction over the person of the accused, let us differentiate it from the custody of the law. Because being in the custody of the law is not necessarily being under the jurisdiction of the court. According, for example, to the case of Mariano versus Toliao, custody of the law is required before the court can act upon the application for bail, but is not required for the adjudication of other reliefs sought by the defendant, where the mere application, therefore, constitutes a waiver of the defense of lack of jurisdiction over the person of the accused. Now, custody of the law is accomplished either by arrest or voluntary surrender, while jurisdiction over the person of the accused is acquired upon his arrest or voluntary appearance. One can be under the custody of the law but not yet subject to the jurisdiction of the court over his person, such as when a person arrested by virtue of a warrant files a motion before arraignment to quash the warrant. On the other hand, one can be subject to the jurisdiction of the court over subject to the jurisdiction and yet not be in the custody of the law, such as when an accused escapes custody after his trial has commenced. Being in the custody of the law signifies restraint on the person, who is thereby deprived of his own will and liberty, binding him to become obedient to the will of the law. Custody of the law is literally custody over the body of the accused. It includes, but is not limited to, detention.
Moving on, the next requisite is the jurisdiction over the territory. This requisite may first be determined by identifying the venue of the commission of the crime, which is a jurisdictional matter and must be established during trial. Otherwise, the case will be dismissed. Venue refers to the place where action is to be instituted. This is subject to existing laws. The criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed or where any of its essential ingredients occurred. It is also important to take note that where an offense is committed in a train, aircraft, or other public or private vehicle in the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such train, aircraft, or other vehicle pass during its trip, including the place of its departure and arrival as stated in Section 15, Rule 110, and where an offense is committed on board a vessel in the course of its voyage, the criminal action shall be instituted and tried in the court of the first port of entry or any municipality or territory where the vessel passed during such voyage, subject to the generally accepted principles of international law. Crimes committed outside the Philippines but punishable under Article 2 of the Revised Penal Code shall be cognizable by the court where the criminal action is first filed. The next part of our lecture will be the criminal jurisdiction of courts.
Criminal jurisdiction of Municipal Trial Court, Municipal Circuit Trial Court, and Metropolitan Trial Court. Hello everyone! MTC is also known as a First Level Court. According to Batasang Pambansa Bilang 129 Section 25, there is a Metropolitan Trial Court in each metropolitan area established by law, a Municipal Trial Court in each of the other cities or municipalities, and a Municipal Circuit Trial Court in each circuit comprising such cities and or municipalities grouped together pursuant to law. Generally, it has jurisdiction over criminal cases where the imposable penalty is 6 years imprisonment or below, except in cases falling within the exclusive jurisdiction of the RTC and of the Sandigan Bayan. MTC also have exclusive original jurisdiction over all violations of city or municipal ordinances committed within their respective territorial jurisdiction. It also has exclusive original jurisdiction over offenses involving damage to property through criminal negligence, violation of BP 22 or bouncing check law, and summary procedure in the following causes: violations of traffic rules and regulations, violations of the rental law, and violation of municipal or city ordinances. All other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 6 months or a fine not exceeding 1,000 pesos, or both. Irrespective of other imposable penalties, accessory or otherwise, or of the civil liability arising therefrom, offenses involving damage to property through criminal negligence where the imposable fine does not exceed 10,000 pesos. Lastly, MTCs also have special jurisdiction to decide on applications for bail in criminal cases in the absence of RTC judges in a province or city.
Let us now discuss the jurisdiction of the Regional Trial Court. The RTC shall exercise exclusive original jurisdiction in all criminal cases not within the exclusive jurisdiction of any court, tribunal, or body, to issue whole departure orders in criminal actions pending before such court. This is as per Supreme Court Circular number 39-97. But the Supreme Court in Santiago versus Vasquez in 1993 said that the Sandigan Bayan also has the power to issue whole departure orders in the exercise of its incidental powers to protect its jurisdiction, and over criminal cases which would normally fall under the exclusive original jurisdiction of the Sandigan Bayan, where the information either does not allege any damage to the government or any bribery, or alleges damage to the government or bribery arising from the same or closely related transactions or acts in an amount not exceeding 1 million pesos. You can see this under Section 4 of PD 1606 as amended by RA number 10660. The RTC shall exercise original jurisdiction in the issuance of writs of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction enforceable in any part of their respective regions. Now, these writs may in certain cases be availed of in criminal cases. The RTC has an appellate jurisdiction over all cases decided by MTC. The RTC shall also exercise special jurisdiction to handle exclusive criminal cases as designated by the Supreme Court. Lastly, the RTC shall have jurisdiction over criminal cases under specific penal laws such as written defamation, violation of the Comprehensive Dangerous Drugs Act of 2002, violations of intellectual property rights, over money laundering cases under the Anti-Money Laundering Act of 2001, except those committed by public officers and by private persons in conspiracy or in participation with public officers, and violations of the Omnibus Election Code except those relating to the offense of failure to register or failure to vote.
For the last part of our discussion, let us talk about the criminal jurisdiction of Sandigan Bayan. The two elements of jurisdiction of Sandigan Bayan that we have to know are to wit. First one is know the crime committed, and the last one is Who committed the offense? What are the cases under the jurisdiction of the Sandigan Bayan? These are Anti-Graft and Corrupt Practices Act, forfeiture, direct bribery, indirect bribery, qualified bribery, corruption of public officials, other offenses or felonies, whether simple or complex, with other crimes committed by the public officials and employees committed in relation to the office, and plunder. Who are now the offenders? Offenders that are under the jurisdiction of the Sandigan Bayan are the following: those officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27 and higher, of the compensation and position classification of 1989, or the Republic Act 6758, specifically including A. Provincial governors, vice governors, members of the Sangguniang Panlalawigan, and provincial treasurers, assessors, engineers, and other provincial department heads. B. City mayors, vice mayors, members of the Sangguniang Panlungsod, city treasurers, assessors, engineers, and other city department heads. C. Officials of the diplomatic service occupying the position of consul and higher. D. Philippine Army and Air Force colonels, naval captains, and all officers of higher rank. E. Officers of the Philippine National Police while occupying the position of provincial director, and those holding the rank of senior superintendent and higher. F. City and provincial prosecutors and their assistants, and officials and prosecutors in the office of the Ombudsman and Special Prosecutor. G. Presidents, directors, or trustees or managers of government-owned or controlled corporations, state universities, or educational institutions or foundations. Members of the Congress and officials thereof, classified as grade 27 and higher, under the Compensation and Position Classification Act of 1989. Members of the judiciary without prejudice to the provisions of the Constitution, chairmen and members of the constitutional commissions without prejudice to the provisions of the Constitution, and all other national and local officials classified as grade 27 and higher under the Compensation and Position Classification Act of 1989. Also, the Sandigan Bayan shall exercise exclusive appellate jurisdiction over final judgments, resolutions, or orders of regional trial courts, whether in the exercise of their own original jurisdiction or of their appellate jurisdiction as provided in Republic Act 10660, amending PD 1606 and RA 8249. In addition, the Sandigan Bayan shall have exclusive original jurisdiction over petitions for the issuance of the writs of mandamus, prohibition, certiorari, habeas corpus, injunctions, and other ancillary writs and processes in aid of its appellate jurisdiction, and over petitions of similar nature, including quo warranto, arising or that may arise in cases filed, provided that the jurisdiction over these petitions shall not be exclusive of the Supreme Court. Please take note, the intimate relation between the offense charged and the discharge of official duties must be alleged in the information.
So, there you go. Our criminal procedure discussion on jurisdiction. Thank you for tuning in. Until our next lesson in criminal procedure. Do not forget to read your books.